Okay, we're ready to go? Are we ready? Sit down. Sit down, Bob. As Richard, yes. Okay, sit down, Bob. Okay, here we go. Thank you, Heavenly Father, for allowing us to meet here. Please open up our minds and our hearts to this law, because all the law is your law. We ask this through your Son, Yahushua. Amen. Do we have any announcements this evening? Okay, we're ready then, Mr. Smith.
As long as it misses the mustache.
Yeah.
Otherwise, it's going to be fuzzy, 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 fuzzy. Last week's transcript came out a lot better, so we're hoping on that. We have not got any of them done yet, but I've been in a crazy state of this flux with a lot of things, and hopefully they will come out pretty soon. Got a document out of Victoria. This has been about 3 weeks ago, and there were some case sites in here that were relevant to a lot of the stuff that is going on in administrative procedure. In the one case, Davila versus Shalala, 848 F Sup 1141, 1994, U.S. District Court for the Southern District of New York, case number 93 CV 4884. This court is to take judicial notice of the following pertinent portions. The matter was remanded to the Secretary for preparation of an adequate record. An interim relief was granted pending the outcome of the determination of the record. The burden of proof is on the Secretary to make a showing upon this court based on that record that plaintiff is not entitled to certain benefits. The court retains jurisdiction until such time as the showing is made. The court determined that the length of time, 5 years, it took before plaintiff got the attention of the agency, and the additional 7 months while the case was at bar superseded the expedited nature of the action. And that explanation regarding the delay of the agency and the lack of evidence to support the agency's position was required to be made via sworn statement by the administrative officer assigned to the case. If you notice what I'm reading here, this case dealt with benefits that the plaintiff was suing the government for, that he believed he was entitled to those benefits. And the problem was that the administrative agency was ignoring everything this guy was doing. And in this court, which was his appellate relief to the administrative agency not responding to him in an administrative process, the court is making some orders and some statements that should be of interest to us under the grounds that, remember, the only remedy you have is to, on the private side, complete an administrative process before you go to court. The courts are not judicial. The courts are appellate to the administrative procedure in Admiralty Maritime. And you make a grave mistake by believing that you're going to take a case into a court for resolution on the judicial side of the court. It does not exist. You take an administrative record to the court if there is a divergence in the opinions of the parties in that administrative proceedings, so that the court will be the public witness to what the administrative proceedings have already brought judgment upon. And so this court is stating that it appears as though there has been a problem on the public administrative side of the government administrative officers with regard to proceedings, in that the administrative department of government failed in what they should have done. And so they're actually helping out the plaintiff in this case, as long as he's on point, to bring before the court the failure of the administrative agency of government. It goes on in the court's statements. The court cited Mcleod versus Sullivan, 501 U.S. 89 at 111. No, at 501 U.S. 89, or 111 Supreme Court 2157 at page 2164, note 2. Quote, "The Secretary bears the burden of proof under the statute of providing as part of an answer to the plaintiff's request for judicial review a certified copy of the transcript of the record, including the evidence upon which the findings and decision complained of by the plaintiff are based." And they give us a reference, 42 United States Code, section 405, subpart G, sentence 3. The court further determined, quote, "If unable to reconstruct the record, the agency could also conduct an expedited investigation to create a new record on which a currently appropriate decision could be rendered subject to judicial review." Notice how the court is going out of its way not to make findings of fact and conclusions of law. This is not a judicial proceedings in a court of law. This is an administrative review of an administrative agency record and decision. And that's the way all treaties, covenants, contracts, and agreements are provided for today in this land in which there is no law, because there is no money of account. The court further goes on, the decision further provided, quote, "where a government agency fails to act with all deliberate speed in performing its duties or correcting its own failure to maintain its own records, the private party should not be placed at a cruel disadvantage because of the resulting delay." See Dollar Dry Dock Bank versus Denning, 148 F period R period D period 124, which is from the Southern District of New York, a 1993 case at note 2. The court cited Zambrana versus Califano, 651 Fed 2nd, 842 at 844, a Second Circuit 1981 case, quoting the case of Ford Motor Company versus the National Labor Relations Board, 305 U.S. 364 at page 373. Quote, "The remanding court is vested with equity powers, and while it may not intrude upon the administrative province, it may adjust its relief to the exigencies of the case in accordance with the equitable principles governing judicial action." Finally, the ultimate decision rendered provided, quote, "It would not be an acceptable outcome to rule that an administrative agency can defeat rights of a claimant to benefits simply by not diligently locating or reconstructing its records. At certain point failure of a governmental agency, like any other party, to supply information which it can provide or reconstruct supports an inference that those materials, if unearthed, would contradict the position of the entity. See generally Gray versus Great American Recreation Association, 870 F. 2nd, 1081, at page 1082. It's a Second Circuit Court decision in 1992. Also the case of United States versus Torres, 845 Fed 2nd, 1165 at page 1169, which is a Second Circuit 1988 case. This would permit a final judgment in favor of the claimant, since no material supporting any of the conclusory statements in the May 14, 1933 letter constituting the final decision, i.e. of the administrative agency, has been discovered, unquote. So what you have here is federal district courts reviewing administrative process and basically stating that when the government administrative agency fails to come out and produce facts and evidence in a record that it clearly should have, that it leads to the assumption and presumption that those facts are counter to the administrative agency's findings and positions, when there are, in fact, no findings of fact or conclusions of law in the administrative record to support their decision. So likewise, when we do our private administrative procedures in preparation to resolve the issue with the governmental agency, and the governmental agency does not respond to us, we need to finish up our private administrative procedure, put it in a form of evidence which clearly could be through the process of a public notary as an officer of the court, to prepare our private administrative record to go into a public tribunal, state or federal, for a second witness or a judicial review of our administrative procedures, which basically would give us the second witness to our process, permitting a public execution then of our administrative process by virtue of the agreement of that court to our procedure. So that's where Cindy, where Winston Strout, a lot of people out west are starting to head in this matter. In the past, new paragraph please. In the past couple of weeks, we have talked about the concept that everything in the public is of dual nature. There is always some kind of presentment in law with a corresponding presentment in equity or admiralty maritime. And we have talked about this duality coming from public officials, both administrative officers, judges, prosecutors, attorneys. We have tended to show by a couple of examples in pleadings and decisions where every lawyer or attorney in every case appears to have a duty to represent both the public side and the plaintiff and the private side and the offender from time to time, and that there is no attorney that represents only one side. All attorneys, all judges, all prosecutors in a case generally bring a duality in all of their pleadings and in all of their tenders of evidence, leaving the parties themselves with the ability to choose whether to stay in law or to go into equity for the form of their proceedings. I am sure that there are many people in this room that have had enough experience in courtroom procedures and legal proceedings to have been drafted from time to time by an attorney on the opposite side, in which a document or a pleading or evidence is served upon you and directed toward you, and the letter accompanying the service or mailing of this document states something like, "The enclosed has been tendered to you for your objection in form if you so choose by such and such a date. And that if you fail to object to the form of the proceedings, that you will have wasted your ability to come back later and object to the form of the proceedings." I would bet dollars to donuts that if you go back and look at all those papers, what the attorney for the other side is requesting of you is an agreement in principle that you will allow the court to proceed in its equity capacity as opposed to the law capacity of looking at the evidence of findings of fact and conclusion of law. And if you do fail to protest or object timely to the form of the proceedings, then you have really assented or consented to the whole proceedings going forward in equity in terms of not only form but also substance, and the court and the lawyers then are in the rules of Never Never Land, that land where Peter goes to, where he flies and never sets his feet on the ground because there's never any reality in any land or soil there upon which the law will apply. Have a comment?
Yes, Jack, just to be on the safe side, if you're approached in a hearing, can you make a statement to court that the proceedings shall be consistent in law? If you cannot, see, sometimes we don't understand what the clever attorneys can say, and you don't even know when you're being petitioned for a response. And so therefore, to play it on the safe side, if it sounds too mumble-jumble, just simply make a statement to the court?
Well, yeah, it's true. It's not what you say, it's what you do. And so one can always make a statement. One can allegedly plead to the court or constrain the court to operate along a certain form. But then the court, like the lawyers claim the Constitution, is not a fixed, firm document. It's basically liquid, and it can move, and it can adjust, and it can change its form.
Well, from that point on, you better be persistent and consistent in law then. Every time they try to move out of law, you have to always bring it back to law.
Yes, you have to, by your acts and actions, stay out of Never Never Land and be in the land of reality in your pleadings and in your responses. The attorneys give you options. but it's up to you because you are the private, and the private side is the only one that has the energy to direct the course of any proceedings. But if the private party is ignorant, or if the private party basically steps away and takes no active participation in guiding the process of the forum, then the public takes over by acquiescence and default and guides you right back to Never Never Land again.
So not only do you have to choose form of law for a proceeding, you have to stay in form of law throughout proceeding.
Correct. And to stay in that form of law means that you have to provide evidence which would be sufficient under the rules of evidence and under the common law to displace and set aside assumptions and presumptions that have crept into the proceedings or are assumed and presumed to be in the proceedings. But also notwithstanding, remember, in terms of remedy, the ultimate remedy is not law. The ultimate remedy and procedure is admiralty. Equity.
Inequity, yes.
So one has to be colorable in what you do in staying in the form, so that it's the colorable procedures that you bring allow you to stay in honor to this equity court, because an equity judge is going to rule on the substance you bring from the law form that you operate in this proceedings.
In my observations of hearings, that every single time came in when the judge would look at, how to say, our patriot who has done everything correctly, and then would say to them, what is it that we can do for you today? It's your time to bring in the document to the court that is your petition and relief and equity.
Yeah, when he says, how can we help you, or what do we want to do today, that is his offering that we will give you whatever remedy you can plead, and then present enough evidence to support that this court should agree with your position.
Well, that I said that as what happens toward absolutely at the end. I mean, when there's all the documents have been entered. I'm not here to testify. I'm here to bring forward documentation in reference to the matter before the court. All that has been done. The court finally says, is that all we have? Yes, both sides, that's all we have. And then the court will always, at the end, I found every single time, they look at the poor defendant in this case, and they'll go, so what can we do for you today? Ignoring, the other side who has, failed. And that happens every time, and then that's where the mistake usually is made. And that some people do it right, and some don't. So at that point, this is a very important juncture as to where do we proceed from here. We've been in law. How can we give you relief? And now you go to equity, and then you get your equity relief, but you have to enter in at that time the petition at which the forms that you petition the court with, and that is with your affidavit and the order of the court requesting the relief to be granted in equity.
Right. So they're really the defendant, actually the offender, and yes, I'll talk about that word in a minute, has been honored in the case itself. And because the lawyers and attorneys are licensed on the public side, which is bankrupt, they cannot bring any claims, so they can't possibly get any execution of remedy and relief, except that the party operating the defendant empowers the court to give the plaintiff the relief through the commercial energy of the defendant. And that relief is going to come either because the person operating the defendant is in a dishonor, and because of his dishonor to the court will extract the commercial energy out of him by granting the judgment to the plaintiff to execute against this defendant. Or else the defendant will act honorably as a creditor and provide the relief notwithstanding from the plaintiff or creditor's exemption. And if one does it in such a manner that you're providing the remedy from the exemption of the defendant's straw man, you are in a law pleadings, a law form, and the final judgment closes the matter, and the operator for the defendant goes home, the account having been closed.
In a hearing, many times if you read your dockets, you'll find that the court refers to defendant 1 and defendant 2. No more plaintiff. You're defendant 1, defendant 2. Okay, what do we have before us?
Because the plaintiff actually had no capacity to prevail.
That's right.
And so he became defendant 2 when he failed to make his claim. The court goes to, quote, defendant 1, the party named in the pleading, and since he is ignorant and provides no adequate pleading and no ability to stay in honor to help the court resolve the matter, his opponent, who you assumed was plaintiff 1, became defendant 2 so that he could get the remedy as a defendant creditor instead of as a plaintiff debtor.
That's correct.
So that's exactly what's going on.
I mean, I know that sounds confusing until you see it happen, but it is the procedure that you're going to be, inundated with. And I know this weekend there's a little practice session going on with Victoria Joy's.
Right. We haven't announced yet today, but Victoria Joy is coming to Cleveland for a seminar for the weekend, August 29th, 30th, 31st. Going to be at the Budget Inn Hotel 14034, something like that, on Brook Park Road, just right off of exit 12 of I-480 in the Cleveland area. So if you can attend, please. You're going to get a lot of good information. I've been talking to Victoria. She's updated even a lot of the material that she gave in L.A., and that was pretty much a brand new seminar.
By experience, I understand.
She does very good at
yes.
teaching.
I didn't mean to get in the middle of your, but I felt that sometimes I get a lot of questions from people, and your explanation of the court procedure needed a little more expanding and a breakdown. And again, and if this is still a questionable, situation, just keep paying attention because there's a lot of experience here, and the fact that after you have a little knowledge, you'd be surprised how far it goes in dispelling the fear that there seems to be prevalent in this condition. And you have to understand those attorneys, they are both working for each other and they're working for the court. And I don't know if any of them's working for you. So that's a very important procedure.
Thank you, Lee. Yes,
You said
Donna.
the lawyer can't do this because we're in the bankruptcy. If you had put him under contract and his esquire in escrow, could he do this game for you?
You're talking about accepting the appointed attorney or the attorney in the case, and by private letter rogatory instructing that attorney as to what you request that he do in order to resolve and close the court case. And the answer is, in theory, that if you put the lawyer under a draft to do a private job for you, absolutely positively he is the agent to carry out that task. The question is, will he do it in fact as though he's going to say to you, why, that's a really great idea, let me just go out and do that. And the answer to that question is he'll never say that. I've had so many people call me up on the phone and say, well, we gave the letter rogatory to the attorney. And he looked at me, looked right in my eyes, and said flat out to me, I can't do that. I won't do that. In fact, we have a gentleman sitting in this room right now who has gone to several attorneys, and he's attempted to try to get them to do that. And basically, the attorneys are saying flat to his face, we will not do that. That doesn't mean you shouldn't draft them, number one. Number two, it doesn't mean that the end result of what's going to come out of the court case is going to be some wild hair just because they didn't, or they said they weren't going to do what you asked them to do. For instance, there have been 2 cases in the last couple of weeks to which both of these parties, one in a civil case and one in a criminal case, put a letter rogatory into an attorney and requested that the attorney in the case operate under private international law as the agent of the undersigned to help resolve 1, a civil case, 2, a criminal case. In both of these cases in the last, I'd say, a month, eventually the attorney in each case put a motion before the court, moving the court for an order allowing the attorney to drop out of the case. A motion for leave to quit the case. Basically, the attorneys alleged that they had differences, quote unquote, with their clients, to which the assumption was the attorney would not be able to do a good job. Now, in every one of these cases and a number of others, the suggestion strongly to the people are, do not let the attorneys out of this case for love or money, ever. And the reason you never let the attorney out of the case is because the attorney is the officer of the court. You are not an officer of the court. You have absolutely no standing to be in that court, speaking with that court. That court is a foreign tribunal. It's a military court, and you're not a member of the military. That's what a democracy is. A military government with the illusion of a civil front government, but all of these tribunals in a democracy are a foreign military court, under a court-martial. That's what an admiralty maritime equity court is. It's the ship's captain sitting at the ship's table carrying out some kind of investigation of something you did wrong for which you've been charged on the vessel. And that's not your court. What the defendant needs, and the defendant is an artificial corporation created by the vessel to do business on that vessel. That artificial corporation, your all capital letter straw man name, needs a publicly licensed entity to represent that corporation in the court. How many times have you been told that a corporation cannot represent itself? It needs a lawyer. What makes you think your straw man is not a public corporation? And you make a deep mistake if you go in there and, quote, represent myself. Oh, what are you, the public agent for the corporation now? So the presumption of an attorney when he goes in with a motion to be able to be dropped off of the case, the presumption is that the client, i.e. the person we've called the offender, is in dishonor to the court lawyer or the court attorney. Now, if the client is in dishonor to the public official, does the public official have a duty to do any commercial activity for the client who's in dishonor to the public official? The answer is no. The dishonor creates the reason for which the public official can be relieved of his duty, because you are in dishonor.
How do we get there?
Well, we didn't. When the attorneys put in a motion to be relieved of their job, they never say we dishonored them. They state a true fact. There is a difference of opinion between the lawyer and the client. It assumes we are in a dishonor. Who's dishonored who here? The attorney dishonored us when we requested by letter rogatory that he represent us to resolve it on the private side. The difference of opinion is the attorney is testing us to see if the private side, law, is going to prevail against the public side, equity, in the way that the public would like to conduct the proceedings. So when the attorney puts in a motion for leave of court in order to quit, it's another test. It's the option between what do you want, law or equity? If you want equity, allow me to quit. If you want law, don't argue with me, you're in a dishonor. But what you have to do is accept all the facts that the attorney made as true. Yes, we have a difference of opinion. But I am requesting of the court that they do not discharge the lawyer notwithstanding. Then you bring in your negative averments, such as, I do not believe I have created a dishonor against the attorney. That's conclusionary. But nevertheless, it can be in there. A fact, I do not believe that any instructions that I gave the lawyer in private are illegal or unlawful. Another negative averment, I do not believe that any instruction that I gave to the lawyer by my letter rogatory would violate his oath of office. I don't believe it would compromise him or this court in its ability to resolve these issues honorably to all the parties involved. And on and on and on.
Did you do this orally or written?
In writing. If it's not in writing, it ain't in the court. Well, unless it's in a public hearing. But that's probably too late, because by the time you're in public, you've already agreed to what the court's going to make as a finding. And the court's already signed the order or created the order before they came out for the hearing. You can't do it in the public hearing in their equity system. It's got to be done beforehand. Now, what really blew us away in these two cases is that in both of these cases, the judge granted the motion and allowed the attorney to escape his duty as the public attorney in the case. And, of course, the court made no findings of fact or conclusion of law, because the judgment of the court was based on what law form? Equity. So there is no findings of fact and conclusion of law. So the judge gets away with it. However, we read last week into the record, what is the substantive foundation of an equity tribunal? What does it found its substance on? Common law. If they created the corporation, one of their agents have to represent their creation. If you choose to represent their creation, have you just got into their business of admiralty, or have they gotten into your business of law? You're in their business of equity, And now don't go complaining that they don't have subject matter jurisdiction, rem jurisdiction, personam jurisdiction. And don't go complaining when they resolve the issue in equity, because that's where they created their corporation. And you're participating in the equity. You volunteered, and now you're going to ask an equity court to find you innocent of involvement in their affairs? I don't think so. What was interesting is not that the judge allowed the attorneys out in both cases. We kind of presumed the judge would do that. After the attorney was left out of the case in both cases, the attorney thanked the court and made a statement. The statement was similar to what follows. Thank you, Your Honor, and I would like to let the court know that if the defendant hires another attorney in this matter, I will be happy to assist that new attorney in whatever I can do to help him in this matter to expedite the proceedings in this court. What just happened? Anybody got a clue? One man said the attorney that was let out of the case just gave honor. Oh, it's much deeper than that. To quote the actor in The Life of David Gale, just needs on the payroll? No, I don't think that's what it's all about. On the public side, the judge just said, "Go, my brother, in peace. You have no more duty to the case." To which the lawyer said, "But yes, I'll do it voluntarily." Hello, which is it? Is he off the case or on the case? The public judgment is he's off the case. But he came back with an offer and said, "But if they still want me, I'm on the case." Privately. What did you turn him into with your letter rogatory? A private lawyer. Wherever you go, if it's honorable, the public is sure to follow. If you turn him into a private lawyer, they will ratify your act by officially taking him off the case as the public attorney. It's perfect. And then this lawyer said, if he hires another attorney, I will do whatever I can to assist them. You know, once it's kind of like, that's strange. Twice, remember what FDR said? There are no coincidences in law and politics. Within 1 week, 2 people talked to me and both parties said the lawyer petitioned to get off, the attorney, and the court let him off, and then this guy comes back and says, "But I'll help out." And I go, you know something? How many sides to a case are there? 2. Public and private. And if you invoke pleadings on the private side of the case by letter rogatory to that attorney turning him into a lawyer, I bet the court has to discharge his public side so that he has the capacity to carry out his contract with you. in which case there's a void in the case that needs filling. A public attorney. Is it possible when the court discharges your lawyer and he's going to work with you on the private side, you have to go out and hire an attorney that your lawyer can work with as a mirror to direct the pleadings from your private lawyer to your public attorney to represent both sides of law and equity in these proceedings? We have no firm conclusions yet. But remember, the Monday night is really about bringing to anybody out there that's interested in trying to understand what's going on in the law form, to understand how these things are.